Welcome back to 2A News Now, and I really do appreciate you taking your time tuning into my video. Real quick, I want to let you guys know that I started a second channel here on YouTube. For a while I've been wanting to make a channel that doesn't have anything to do with the Second Amendment, but covers politics and current events. The name of the channel is You Can't Handle the Truth. For right now it's just going to be short videos. And I've only posted one video on there so far, but I'm going to try to upload at least one a day. So go check it out. Once again, it's called You Can't Handle the Truth. Hopefully you like what you see and subscribe to the channel. This is some really good news. The Supreme Court is finally taking up the bump stock case. And I know there will be those out there that will say, well, I don't care anything about bump stocks. This will impact all the other Second Amendment cases that will come before the Supreme Court. The Supreme Court will decide whether the Trump administration's ban on bump stocks, implemented by the ATF in 2018 after the Route 91 Music Festival shootings in Las Vegas, was a proper exercise of the ATF's authority or an overreach on part of the administration. On Friday, the court granted cert in a case called Garland versus Cargill, one of several cases that have been bouncing around the lower courts since the ban was first put in place. The court's granting of the case wasn't exactly a surprise, for a couple of reasons. The Solicitor General had sought Supreme Court review, but there are also splits in the federal appellate courts over the legality of the ban. The Fifth Circuit had ruled that the bump stock ban was improperly put into effect, while the D.C. Circuit, the Sixth Circuit, and the Tenth Circuit have all allowed the ban to remain in effect. The question before the court is whether a bump stock can be considered a machine gun under the statutory definition provided by the National Firearms Act. Any weapon that shoots is designated to shoot or can be readily restored to shoot, automatically one shot without manual reloading, by a single function of the trigger. The term also should include the frame or receiver of any such weapon, any part designed or intended solely and exclusively, or a combination of parts designed or intended for use in converting a weapon to a machine gun, and any combination of parts from which a machine gun can be assembled if such parts are in possession or under control of a person. Bump stocks can increase the rate of fire, but still require a separate pull of the trigger before a round is discharged. For years, the ATF maintained that bump stocks were not machine guns, but reversed course after Donald Trump ordered the agency to review its findings in 2018. And son of a gun, the ATF reversed course and declared the previous guidance addressing bump stocks without internal springs did not reflect the best interpretation of the term machine gun. Michael Cargill, owner of Central Texas Gun Works, challenged the new rule shortly after it went into effect, while a district court judge and a 3-judge panel of the Fifth Circuit Court ruled in favor of the government. An en banc review by the Fifth Circuit Court overturned these decisions, with the majority agreeing that the rule of lenity requires interpreting the statutory definition of machine gun not to encompass bump stocks. Now this is the part I want everybody to listen to, that they don't care about this bump stock case. The court's ruling in this case could also end up having impact on the Biden administration's use of ATF rules to impose new restrictions on pistol stabilizing braces and unfinished frames and receivers. It seems important now, doesn't it? Which the agency has largely reclassified as short-barreled rifles and completed firearms respectively. Besides the Cargill case, the Supreme Court also granted cert to a Second Amendment adjacent case involving the National Rifle Association in the NRA versus Vullo. The court will determine whether the actions of the head of the New York's Department of Financial Services violated the First Amendment rights of the Second Amendment organization by using back-channel threats, ominous guidance letters, and selective enforcement of regulatory infractions to induce banks and insurance companies and avoid doing business with the 2A group. Again, the stakes here are pretty clear. If the court finds that the actions of the DFS head are acceptable, we can expect more anti-gun officials in states across the country to pressure outside groups from associating with and doing business with Second Amendment organizations or other groups disfavored by the party in power. Everybody should be thrilled to see both of these cases being accepted by the Supreme Court. But given the appellate court split on the bump stock question, I don't think SCOTUS had much of a choice but to take the case. Everybody hopes there are 5 justices ready and willing to to rein in the executive branch overreach that begun during the Trump administration, but has been greatly expanded under Joe Biden, as well as putting a stop to First Amendment abuses practiced by New York State officials. These cases will be heard sometime in the first half of 2024. And hopefully we can finally put this to bed, and the Supreme Court will rule these cases are unconstitutional. And if people want to buy bump stocks and put them on their firearms, so be it. But like I said, these cases have further implications when it comes to the pistol brace rule and the frame and receiver rule. As always, I would really like to hear your thoughts about today's video in the comment section down below. And if you guys would do me a favor and help the channel out and help it grow and get us over that 60,000 subscriber mark. If you would just take a few seconds and like, share, and subscribe and hit those post notifications. And I hope you guys come back and watch my next video.